Good evening, friends. Welcome to this lecture. And the topic for today's discussion is brutality behind bars. Is custodial torture a necessary evil? The objective of my lecture is not to undermine the law-abiding police officials and their professional capability, but to make a critical analysis about those few rotten apples in the police force who violate the rule of law consciously, deliberately, and violently. Some of the questions that we need to ask ourselves before we understand this critical issue. The most immediate case of custodial torture that comes to our mind is Jeyaraj and Bennix. Some of the genuine questions the people have today are: what are the reasons for brutality behind bars? Why do the underprivileged sections are being targeted when the politically influential and the dominant sections of the society are able to get away easily without any punishments, even when they are found guilty? Is custodial torture a necessary evil or violation of human rights? Why do the law-abiding police officials maintain silence when some of the rotten apples in the police force violate rule of law knowingly? The next question that we need to ask ourselves: what does history tell us about police torture and brutality behind bars? Well, the recent custodial torture cum death of Jeyaraj and his son Bennix in Tamil Nadu has outraged public opinion. Almost all sections of the society have raised their voices in protest against brutality beside bars, as we all know. And secondly, we also understand that the shock waves created by this insensitive and inhuman incident have transcended the borders of Tamil Nadu, unlike in several other cases, and traveled across the country, even different parts of the world, thanks to social media, social activists, celebrities, and so on and so forth. But now the question is, what kind of issue that we are talking about? Why do we need to take it seriously? Most importantly, the newspaper reports, I'm talking about the recent incident that happened to Jeyaraj and his son. The newspaper reports tell us very clearly that the clothes of Jeyaraj and Bennix were fully soaked in blood. They had to keep changing their clothes due to severe bleeding. We also come to know that the brutal policeman asked the family members mercilessly to bring dark-colored lungis. What does it tell us? The brutality and torture raises, therefore, a series of historical questions. It is in this context we need to understand the history of police in India, how the torture as a third-degree method was seen and has been seen by few officials as a legitimate method in various parts of the world. And let me begin this important issue by making an observation of a statement made by the former Chief Justice of India, A.S. Anand. And particularly, this is in the context of torture, an international conference on torture that took place in 1999. And the Chief Justice of India also was one of the speakers. Let me quote him. The quote begins, "Basic human rights are the entitlement of every citizen. Protection of human rights is the obligation of every civilized state. Nevertheless, in the recent past, the word torture has become synonymous with the dark side of human civilization. Torture is the very antithesis of human dignity, as it cuts at the roots of the culture of human rights," unquote. I don't need to explain this particular statement, because the statement speaks for itself very clearly. So it is in this context my lecture is centered around three important historical factors. How these three historical important factors by different police officials consciously and deliberately. The first important historical factor is for the first time in the history of India, since 1861, remember 1861 is the period when Indian Police Act came into force. And since 1861, for the first time in the history of modern India, has ordered for a police station to be taken over by revenue officials. Remember, for the first time. So before this particular incident, we hardly have any example where a court is ordering a police station to be taken over by revenue officials. What does it mean? This means a lot. It means the people have no faith in the credibility and capability and transparency of the police, and the court itself has expressed it very clearly that, sorry, we cannot believe you. Somebody else has to take the responsibility on your behalf. And the second important historical factor that I would like to emphasize here is the violation of the Code of Conduct of 1960. It's very clear. What is this Code of Conduct is all about? The Code of Conduct for police in India was adopted in independent India, I'm talking about, for the first time at the Conference of Inspector Generals of Police in 1960. And this particular Conference of Inspector Generals made it very clear what is the responsibility of the police and what is the responsibility of the judiciary. It's very clearly mentioned. Even an LKG, UKG student will be able to understand this instruction very clearly. It states that the police must be faithful to the Constitution of India and respect and uphold the rights of the citizens as guaranteed by it. Secondly, the conference also underlines that the police is essentially a law enforcement agency, and therefore it should not assume the function of a judiciary. And consequently, the police cannot sit in judgment on cases. It's very clear. And lastly, the conference of 1960 makes it very clear that it under no circumstances, remember, under no circumstances should the police punish the guilty. So who punishes the guilty? It is the function of a judiciary. Now we see the other way around. Police punishes and judiciary keeps silence in most of the cases. And the third important factor that I would like to emphasize here is, again, it is an observation and order, in fact, comes from Supreme Court of India. The Supreme Court of India in 1987 itself made it clear that dehumanizing, torture, assault and death in custody raises series of questions about the credibility of the rule of law and administration of criminal justice. I repeat, this is a very, very important, because whatever we see today, it's completely in violation of what the rule of law says. I repeat once again, this Supreme Court of India's order, which passed in D.K. Basu versus West Bengal case in 1987, it makes very clear. Dehumanizing, torture, assault and death in custody raise series of questions about credibility of the rule of law and administration of criminal justice. Okay, so these three important reasons as a student of history make me understand that all is not well within the police system. The available multidisciplinary studies therefore suggest that police as a law enforcing agency has been playing a crucial role in preventing crimes to a large extent in independent India. That's true to some extent. Nevertheless, the ways in which instances of brutality behind bars being reported almost on a regular basis, and the manner in which custodial torture is seen by some of the police officials, I'm not saying all the police officials, some of the police officials as a necessary evil, indicate therefore that the law enforcing machinery needs to be looked very, very critically, now more than ever before. And it's my observation, therefore, the custodial torture happened to people like Jeyaraj and Bennix would only weaken the law-abiding citizens' faith in the credibility and capability of police. There are many studies on custodial torture, and most importantly, A.G. Noorani has done a wonderful work on custodial torture. Nirman Arora has done a very, very important work titled Custodial Torture in Police Stations in India. Similarly, you also have a brilliant study made by R.S. Saini, Custodial Torture in Law and Practice, with reference to India. And you also have studies made by S.P. Seth, Liability of a Police Officer for Custodial Death. And there are many studies I can keep quoting. But now the question is, these studies tell us a lot about the historical account of what is going on, of what we face today. At the global level, if you look at the history of torture, the history of brutality behind bars, it's very interesting. An effective police system as per the United Nations General Assembly. Always remember, when I talk about at the global level, we are getting some important insight from the United Nations as an international body. And most importantly, in 1979, I'm talking about is a very, very recent period, this global organization made a series of international conferences to address the brutality behind bars and how the police should function and what is the responsibility of the police in a civilized society, and how therefore police need to be accountable and approachable in different circumstances. According to this 1979 resolution of the United Nations General Assembly, an effective police system is the foundation on which the whole edifice constitutional will, maintenance of law and order, detention of crime, and enforcement process of social legislation rests. So this is how the United Nations General Assembly tries to project and give importance to the effective police system, And therefore, you might ask a question, what is the efficiency of an effective police officer? What is the responsibility? So it is in this context, the role of police in a society can best be described in the following words as laid down in the Law Enforcement Code of Ethics, again the United Nations General Assembly. I quote, it's very important because every police needs to know this very basic ethics of his or her profession. It says, I quote, as a law enforcement officer, my fundamental duty is to serve mankind, to safeguard lives and property, to protect innocent against deception, the weak against oppression or intimidation, and the peaceful against violence and disorder, and to respect constitutional rights of all men to liberty, equality, and fraternity. Remember, it's beautifully described. If any police official who reads this can never, ever violate the rule of law, because it's so simple. And secondly, we also have a very important guidelines from International Rehabilitation Council for torture victims. The most likely perpetrators to be involved in torture and other forms of ill treatment, it's clearly mentioned, are the police, military, paramilitary forces, state-controlled forces, government officials, health professionals, and co-detainees acting with approval or on the orders of public officials. So everyone in this respect is supposed to respect this particular instruction of the United Nations General Assembly. So now the question is, what is the reality in India? Whether the police officials, I'm not talking about again the entire police system as such, but only the rotten apples in the society, in the system. Coming back to the Indian scenario, it's very simple. As we all know, Article 20 and 21 of the Constitution of India provide very clearly that no person shall be convicted of any offense except for violation of law in force at the time of commission of the act charged as an offense, nor be subjected, remember, nor be subjected to any greater penalty than that which might have been inflicted under the law in force at the time of the commission of an offense. It's very clearly mentioned in the articles of the Indian Constitution. So the question is, therefore, the rule of law needs to be emphasized. As it is already mentioned, the rule of law means that no one shall be deprived of his or her liberty except with the authority of law, and all persons therefore shall be equal before law. That we all, I think, know it very clearly. And it also talks about the custodial torture, because since the seminar, this particular talk deals largely with custodial torture, I think I would like to give more importance to this particular issue. The custodial torture or inhuman treatment, it could be handcuffing prisoners, third-degree methods, which are often used and practiced by some police officials during the course of their official duties. And obviously, these instances of custodial torture are against the norms of the civilized nations, and therefore these are considered as barbarous activities and violative of the principles of the rule of law and human dignity. Now the question is, most of the time we ask a question: what is the objective of a police? The main objective, as we discussed, of the police is to apprehend criminals, to protect law-abiding citizens. Very important, to protect law-abiding citizens, to prevent commission of crimes, and to maintain law and order in the society. And the question is, torture has been practiced frequently in different parts of the world, and particularly in India, regardless of the government in power. And secondly, torture is committed on a regular basis by enforcement officials in the course of criminal investigations. And in India, the main perpetrators of torture have been police officers and other law enforcement officials, such as paramilitary forces, and those authorities, particularly in Tamil Nadu. In this case, there is something called Friends of Police. I don't know how far they are constitutionally valid. It has to be seriously looked into. Friends of Police. I don't think there is any scope in the Constitution of India to recruit something called police, Friends of Police, because they are also responsible for this torture, as we read from newspaper reports. And the most important thing, which I personally feel is the violation of rule of law, is how some of the police officials continue to violate what is described in the 1986-87 Supreme Court judgment. It's very, very important. Remember, I think some of you may be aware of the case D.K. Basu versus West Bengal. So in the case of arrest, the Supreme Court instructed all the law enforcement agencies to make sure that the following guidelines need to be followed very carefully. The guidelines need to be followed very, very clearly in 1987. So it's most importantly, there are many important instructions given by the Supreme Court. For example, the police personnel carrying out the arrest and handling the interrogation of the arrestee should bear accurate, visible, and clear identification and name tags with the designation. But the question is, very few officials do. And secondly, in the 1987 Supreme Court order also says that the police officer carrying out the arrest shall prepare a memo of arrest at the time of arrest, and such memo shall be attested by at least one witness who may be either a member of the family of the arrestee or a respectable person of the locality from where the arrest is made. Again, I'm sorry to say that this also most of the time is floated by the officials. And third important suggestion made by the Supreme Court, in fact it's an order: a person who has been arrested or detained and is being held in custody in a police station or interrogation center or other lockup shall be entitled to have one friend or relative or other person known to him or having interest in his welfare being informed as soon as practicable. Remember, how come these rotten apples in the police can consciously violate the Supreme Court order. Similarly, the time, place of arrest, and venue of custody of an arrestee must be notified by the police where the next friend or relative of the arrestee lives outside the district or town through legal aid organization within a period of 8 to 12 hours after the arrest. When I was reading this, I was really speechless, because in the case of Jeyaraj, the people who were in the station, even after 48 hours, were not able to tell the family members exactly what happened to them, what was the exact position, what was their social plight, what was their physical condition. So this is in fact a clear violation of the Supreme Court order. And it's very important, the Supreme Court also says that the person arrested must be made aware of his right to have someone informed of his arrest and detention as soon as he is put under arrest or is detained. It's very simple. In most of the cases, this particular order of the Supreme Court are not taken seriously. Is something that we need to be very critical and serious. And as a result, we need to know what exactly we need to be clear in this particular issue about custodial torture. There are many studies, as I told you already. For example, P.D. Malaviya, why do police change? Police on crossroad. Basu, in his study, use of discretion in police. And similarly, you have so many commissions: Law Enforcement Administration of Justice, President's Commission, and the Police Public Relations Commission. I have gone through at least a couple of commissions' report, which tell us clearly that in most of the cases, what I call this custodial torture is clearly visible and explicitly expressed in their actions. And the next important thing that we need to remember, as we all know, from 1861 onwards, the history of police therefore can be traced back to 1861. It was introduced in the Indian Councils Act of 1861. Interestingly, this act created the foundation of a modern and professionalized police bureaucracy in India. And it introduced a new cadre of police called Superior Police Services, later known as the Indian Imperial Police Service. And here, the colonial government, remember, the colonial government had a different ideological orientation when they introduced this Indian Council Act. And they considered, in fact, they made it very clear that the policing is a sign of maintaining peace and order in an ever-changing society. And the society of today, naturally, therefore, as we understand, compared to the colonial government, the society of today, I'm talking about the contemporary society, is not the same of previous years, as we all know. It has become more complex. Its aspirations and expectations from the people when crimes happen, therefore, put a lot of pressure on the police as well. I'm not going to deny all these things. But the question is, policing philosophy or policing methods and the attitudes of those responsible for policing therefore cannot remain the same. I am not therefore justifying what the custodial torture need to be justified under any circumstance. No, I am not advocating. But the question is, the police officials therefore must keep space with the changing needs, keeping the law and constitution into consideration. And it is in this context, let me give a little more emphasis why we need to talk the custodial torture today more than ever before. Because if you read this history of R.S. Saini as an authority on custodial torture, the custodial torture in law and practice with reference to India, he very clearly defines what exactly the torture is all about. How does he define torture? He says, torture usually denotes intense suffering, physical, mental, and psychological, aimed at forcing someone to do or say something against his or her will. It also means breaking down under severe physical pain and extreme psychological pressure. The suspect, therefore, in these cases, these custodial torture cases, are detained in some isolated places beyond the reach of the family, friends, and legal assistances. Interrogators, therefore, control everything, including their life. For obvious reasons, torture is not called torture by those who practice it. Remember, torture is not a torture at all for those who practice it. The torture can be through various forms. The torture itself has different avatars. For example, torture can be identified as sustained interrogation. And it can also happen through questioning a person. And it also can be done through examining. So the question is, whatever the name you call it, brutalization, therefore, is the result always, either physically or mentally or psychologically. I'm not talking about severe criminals or the terrorists who have a history of crimes. I'm talking about those people who have no history of crimes, the people who are disprivileged or underprivileged, who have no history of crimes. I'm talking about more people like Jeyaraj and others in this particular question. So now the question is, the phenomenon of torture is very old. When I was reading some of the important literature on torture, I found out that until the 18th century, remember, until the 18th century, physical torture was legal and official, and officially, in fact, allowed as a method of interrogation in many countries. And it was only after the Second World War, remember, it is only after the Second World War that the torture, just like other modes of violation of human rights, figured prominently and became a matter of international concern. And why I'm saying this Second World War, most importantly, here the United Nations comes, and which organizes a series of international conferences to address the human violation. So I therefore think, without making reference to the role played by United Nations General Assembly or United Nations, it's incomplete. The entire lecture of mine will be incomplete. So the prohibition of torture, therefore, has been advocated ever since the adoption of the Universal Declaration of Human Rights in 1948 and the Geneva Convention in 1949. So as historians or anyone who is listening to this particular lecture, I think, need to be clear now So the history of human rights can be traced back to this Universal Declaration of Human Rights in 1948 and the Geneva Declaration of 1949. But it was only in the 1984 that the UN General Assembly for the first time adopted the Convention Against Torture, 1984. And later India also started taking up 1987, because remember, whatever was explained in United Nations also reflected in different parts of the world. And in 1987, immediately, the Basu versus West Bengal case is also clearly mentioned. The term torture is also being reflected officially. And therefore, the convention, beside other things, United Nations Convention, beside other things, carries the definition of torture. As I've told you, it's very clearly, for the purpose of this convention, the term torture means any act which severe pain or suffering, whether physical or mental, is intentionally inflicted on a person for such purposes as obtaining, remember, as obtaining from him or her or a third person information or a confession punishing him or her for an act he or she, a third person, has committed, intimidating or coercing a person for any reason based on discrimination of any kind, when such pain or suffering is inflicted by or at the instigation of or with the consent of acquaintances of a public official acting in official capacity. This is a very, very important definition that everyone should be aware of it. And most of the time, the question we ask ourselves is custodial torture a necessary evil or a violation of human rights? Most importantly, when I was reading, some of the important officials in India, I'm talking about, they were advocating the idea that custodial torture is a necessary evil. You know why? Let's see that. What is more reprehensible, therefore, and lamentable is the move to legitimize and justify custodial torture than torture itself. Remember, custodial torture is more dangerous than torture itself. Custodial torture has become a systematic and to a larger extent state-controlled phenomenon. It's very, very important thing that we need to remember. For example, I have gone through studies made by Sudeep Majumdar, Death in Police Custody. Maybe some of you can go through it. And this was a book edited by A.R. Desai, in fact. A violation of democratic rights in India. And here, some of the police officials do justify the third degree methods. For example, very often police, in fact public like you and me, when some crimes happen in the society, obviously and naturally we become so emotional and we expect police to do something immediately, isn't it? Yes, of course, I also did many times. When something happens in society, when rape happens, or when a crime happens against women or any individual in the society, any responsible public would immediately point out police. Police is not doing its job properly. Police has failed. Therefore, what I feel is police therefore has been sandwiched between the rule of law on the one side and the expectation of the people on the other. So I am not blaming therefore the entire police for what they're doing is entirely wrong. But they also have a reason. For example, very often public like you and me expect police to give sound thrashing to the so-called gundas and the people of bad characters. In the same case, for example, pickpocketing and property theft, the victims urge the police to adopt third-degree methods. Kill him, stone to death, kill him. So there are so many people who come to streets, and that's so police also has to take action, and it also increases the pressure on the part of police, and therefore we understand what is going on in the society. So there are other side of the story as well, and it is in this context we need to remember, as I have pointed out, Sudeep Majumdar's work. An expert, remember it's very carefully crafted. An expert from a superior power intelligence force was called upon, I'm talking about the Indian case, to train the policemen in the latest methods of torture. In 1970s, I'm talking about 1970-71, an expert from a superior power intelligence force was called upon to train the policemen in the latest methods of torture. I don't want to go into the details of what kind of methods they were adopting in 1970s. And the senior police officers, bureaucrats, and politicians therefore justified it as a necessary evil. This is the history of 1970s. So these police officials, bureaucrats, politicians therefore did justify that it was a necessary evil. You know why? To curb the growing crime rate in the society. And on the other side, obviously, you always have enlightened officials, like any other department. You also had a group of enlightened officials, and they said, sorry, we will never accept this latest methods of torture. But they made best efforts to curb custodial torture. So in the book itself mentions the name of the police officials called Vijay Karan, the former police commissioner of Delhi, for example, who not only openly condemned this latest methods of torture, but also made his best efforts to curb custodial torture. Of course, therefore, you also have officials who are respect rule of law, who respect the people's right to live. But the police force in general, therefore, had different views about this particular methods of torture, including third-degree torture. But now the question is, they have a couple of points to justify why they want to justify this, custodial torture. For example, the first important reason why the police justify and support the custodial torture on the following grounds. Number one, the police force is facing the problem of inadequate strength compared to increasing rate of crimes that we all know. And therefore their task is overwhelming, which goes far beyond the duties of enforcing the law and controlling the crimes. And they hardly find adequate time for proper investigation and direct detection of crime. And that is the reason why they are forced to adopt third-degree methods, which they think become inevitable. And secondly, second justification of some of the officials is that hardened and professional criminals understand the language of violence only. That is why some people would normally make fun of others. Okay, let us talk the same language the enemy understands. So, obviously, the police also has a language to make the criminals understand, and therefore they justify the custodial torture. And thirdly, there is no harm in using violence against criminals like terrorists, dacoits, and others who are very serious threats to the society. So this also is a prevalent view among some of the police officials who follow custodial, who support custodial torture. And now other important justification, therefore, the legal procedure is very complicated. For some officials, they think that the legal procedure is very complicated and always in favor of the criminals. Maybe it may be true or may not be true in some cases. Therefore, the police has to work under heavy legal odds. They have to establish the crime in the court beyond doubt. If you don't do your duty, you will be forced to hang your head on shame before the justice, before the court. So what did the police do? Therefore, under any circumstance, they have to do to get the certificate that, well done police, you have done the duty that you are supposed to do. And therefore, they also try to follow this third-degree torture to justify their way of functioning in the police department. And therefore, there is virtually no facility for scientific investigation. They also think, another justification of custodial torture, they think, sorry, we don't have any scientific facility for investigation and detection of crime in most of the police stations. And so the police has to rely on third-degree methods. This also, in most of the cases, they say openly. And you also have the justification from the police that detection of the crime and conviction in the court is considered by the society as a proof of efficiency as a good police officer. So let us think very genuinely. If I am a police officer, I'm not a police officer in fact, if I'm a police officer, if I want to get attraction of the society, I will make every effort to prove myself as a credible officer. That doesn't mean that I have to violate the established rule of law violently. That's the point that I am emphasizing here. So the point therefore is, most of the time we don't have to blame the police entirely, because we, the people, also are responsible. The behavior, the mindset of police, the expectation of people, that therefore it keeps increasing about the credibility and capability. If something goes wrong in the society next door, and immediately you go to station and condemn the police for their inefficiency, you will ask a question, are you sleeping? So the police also has to be very careful in their profession. And similarly, what I'm trying to emphasize here is people want the police to prevent and control crime, but are unwilling to cooperate in most of the cases. That's what the police claims. And they rarely give witness against the criminals. So the police has to extract information about the crime from the criminal concerned, which is hardly voluntary. If you ask any person, have you done this? Do you think that the person will say yes? I don't think so. But that doesn't mean that innocent people have to be tortured, or the suspects need to be tortured. Because remember, the rule of law says in the 1960s, punishment is not the duty of police. It is the judiciary which does that job. Punishment is not at all the duty of police. Punishing is not the duty of police. That's the point that I'm emphasizing in this particular discussion. So the point therefore is, despite all these justifications given by police, for custodial torture, we also need to remember, because of these justifications, remember yesterday I was reading one important report from the Hindu published on 30th June 2020. Over 1,700 custodial deaths were recorded between 2001 and 2018. 2001 and 2018, there were 1,700 custodial deaths reported. And you know how many policemen were convicted? I'm sorry to say, only 26 policemen were convicted. Only 26. The deaths were 4-digit, and the people who were responsible for the death are only 2-digit, 26. So this raises a series of questions. And Jeyaraj case is also very important and historical on various reasons, on various grounds. And therefore, there are issues and challenges. Generally, police officers investigating deaths in custody normally are more concerned about shielding their colleagues than bringing them responsible to justice. Let's talk plainly. How many police officials are really interested in taking a serious investigation about his or her own colleagues? It's $1 million question. So the issue number one is police officers investigating deaths in custody are more concerned about shielding their own colleagues than bringing them before justice. And secondly, when Indian police typically blame deaths in custody on suicide, they blame, oh, this person died because of suicide. This person died because of illness. This person died because of natural causes. But in most of the cases, it is not so. Family members, on the contrary, of victims frequently claim that the deaths were the result of torture and ill treatment of the police. And secondly, Indian law and the Supreme Court have laid down procedures for law enforcement that deal with various aspects of police work, including registering cases, the treatment of arrested persons, and the conducting questions. Now the question is, how many of the police officials are seriously following the instructions and the rules prescribed by the Supreme Court of India? That's also another important issue that we need to talk about. And now, as a result, many scholars that I can think of and many Supreme Court judges were therefore very critical about the torturous punishments given by some of the rotten apples in the police force. Now the question is, what do we expect? What are the possibilities that we can think of for a change or transformation or change in the mindset of police? Not all, maybe some of them. For example, I have a couple of things now before I close this talk. What I personally feel is police should be trained to handle all kinds of situations because they are public servants. Their job is to address public issues, as we all know, 24/7, and they are not supposed to vent out their frustrations, anger, resentment, mental agony on innocent people. And the need of the hour is therefore a complete renovation and reformation in the system. And secondly, the police must change its attitude and behavior while dealing with law-abiding citizens. They need to discern. They have to have the capability. Who is criminal? Who is innocent? And most importantly, therefore, they are finding it very, very difficult to differentiate the law-abiding citizens, the witnesses, the suspects, and the criminals. And it is therefore the need of the hour that the state must invest more in its enforcement agencies and ensure that the police laws, its perpetual tag of being abusive and torturous. Again, the state has more responsibility. We all know that it's completely it's very difficult to separate state from the police because they are interconnected. But what I'm trying to emphasize here is the state has a crucial role to play, that a proper training or the perpetual tag of being abusive and torturous can be removed. It's a very, very difficult question. And thirdly, the prevailing situations. There are many discussions and debates all over the world about torture, right from the United Nations. Then you have a Supreme Court of India and so many other international organizations, Amnesty International, for example. All these institutions talk about reforms, particularly about criminal justice system, most importantly policing, and they all think that despite reforms in words, police and the enforcement agencies should be action oriented, meaning they all should respect what is already there. I'm not talking about anything new should be introduced. For example, as I told you, remember 1960s, the Inspector General's Conference has come out very clearly what is the duty of a police, what is the duty of a judiciary. It is not a duty of a police to punish the people, it is the judiciary. And similarly, 1987 case, Basu versus West Bengal, we also know very clearly. And therefore, let me conclude this talk by quoting one of the most important observations made by Supreme Court Justice. And this fact, this particular statement was made in 1999. And this was made when the International Conference on Torture was taking place in New Delhi in 1999. Justice V.S. Malimath, M-A-L-I-M-A-T-H, Malimath, made this statement very categorically. I think this is very, very important. I quote him: "The prevention of torture could only be achieved when the animal instincts in human beings are tamed." It's a very, very powerful statement. The prevention of torture could only be achieved when the animal instincts in human beings are tamed. Obviously, we all know that's going to be the biggest challenge before humankind. So it's a very important, therefore, this particular case, Jeyaraj Bennix, really opened up a new chapter in the history of torture. So now, as I told you, the concerned police officials who lack in transparency, capability, and professionalism need to be self-critical, need to self-introspect. What is going on? Why there is such custodial torture need to happen in the society, particularly a society of a civilized country, of a civilized society. As I told you, therefore, it's a time that every one of us should think. And as I told you, I'm not blaming the entire police system as evil, but as every society, every section has rotten apples in its own realm, and the police also has some rotten apples, and they need to really be critical of themselves, their profession, and they have to make sure that human rights violations are not taking place, and history does not repeat what happened to Jeyaraj and Bennix. So with these words, let me conclude my observation rather on this particular topic. So thank you so much, friends, for your patient listening. Thank you so much.